I will now call the next case on the docket, State of Kansas versus Jorge Contreras, case number 127830. Ms. Allen, when you're ready.
Hey, please the court. Christy Allen, Assistant District Attorney, appears on behalf of the state. This morning, I feel like we have a lot to get through, but I do want to, when I start, I want to make sure that I'm clear and provide some context. I believe there are two issues in this case that we need to be clear about which issue we're talking about. There's an error analysis. Did the error occur? And if the error occurred, what analysis do we use to consider whether it requires reversal? So I'm going to try and be very clear when in my argument and differentiate between the two. To begin with, and I recognize this was not in my opening brief, but to begin with, it was included in my petition for review. The state believes that this issue is not properly preserved. I would submit that under Supreme Court Rule 6.02A5, the defense has an affirmative duty to set forth the preservation of an issue and explain, if it is not objected to below, why this is properly before an appellate court. In this situation, the defendant argued two exceptions and then cited, I think, 3 cases and 3 sentences as to why the issue is properly before the court. The state would submit that citation alone is not enough and would cite this court's opinion in Shute v. Foster, where just a mere citation to other Apprendi issues is not explanation sufficient for preservation. Moving on to the error analysis, very briefly, the state would submit that there was no error, first of all, because Mr. Contreras was charged in adult court under the Kansas Criminal Code. A person 18 years of age or older is charged under the Kansas Criminal Code. If a person is younger than 18 years of age, they must be charged under the revised code for juvenile justice. There is nothing in this record that says that the case was initiated under the juvenile justice code. Therefore, the reality is he is 18 years of age or older. Therefore, there was no fact finding necessary by the court in this situation.
Would you agree that it is a fact that increases the penalty? It's a fact subject to Apprendi, I guess I'd put it that way.
I understand that this court has found that it is a fact subject to Apprendi.
Do you disagree with that?
I don't disagree that being 18 years of age means lifetime post-release supervision.
So it's subject to Apprendi?
It is subject to Apprendi,
which
correct.
Means it must be found by a jury.
Except under this court's findings and even Nunes, it can be admitted by a defendant.
Right.
And so I understand
I understand the reason for the argument that he was tried as an adult. In all these cases, various parties and perhaps even the court are looking for places in the record where we can point to say, this shows this defendant was over 18. In this case, it's particularly, I don't know what the right word is, obvious, egregious, whatever. Like, this defendant was over 18. Everyone knows that.
Right.
The problem is,
right,
and it remains an important problem, and we can't just sort of close our eyes and say we all know this to be true, even if the procedures weren't.
And I understand that, and I don't necessarily disagree, but I think that then that also goes into the analysis that you have on whether it was harmless error. In this specific case, I think there are many cases out there that in deciding whether or not it's error, and in this panel in particular, the panel decided that it was error and therefore it could not be harmless. And that is not what this court has said many, many times. And so when we so if you're not going to agree that just because you're 18, a jury doesn't have to find. And I know this court said in Nunez that any jury trial waiver has to be to the defendant's admission.
Isn't that the real question? Isn't that the central question of this case is, was Nunez's, was Contreras's jury trial waiver sufficient?
Correct. Yes, the state agrees with that. The Court of Appeals panel on this case seemed to say that because there was no waiver beforehand or there was no explicit advisement as to age being decided by a jury beforehand, that is error.
That's the question. At least it seems to me, I want to ask if you agree. It seems to me that's the question before us in this case. Was the Court of Appeals correct in its interpretation of Nunez that a proper jury trial waiver has to occur at that sort of granular level?
No. And here's why. Because we have several cases of precedent that say when a defendant waives a jury trial, so we're talking about a general jury trial waiver, then that is sufficient to find that there was no error for Apprendi. And when you look at, so Nunez was different because it was a jury trial. So there was
no waiver.
There was no waiver of anything.
Do you agree with the Court of Appeals statement that Nunez changed Kansas law?
I agree that Nunez changed a view of determining if there was error. Because if I read the cases prior to Nunez correctly, then in State v. Conkling, I think it is, because there was evidence of the defendant's age within the record, the financial affidavit, other issues, because there was evidence, that court found that there was no error. You don't have to do the harmless part. There was just no error. And so I think Nunez, this court said, because I think in Nunez, there was also an age and a financial affidavit.
Yeah, the case and the line of cases dealt with the practice of a judge making an age finding after a jury verdict based on PSIs, affidavits, those kinds of things, right?
Right. And here you don't have that. You don't have the after finding. You have all of the information that's presented beforehand. And so I think that changed the error analysis from what it has been, but that does not mean that it should change the harmless analysis, which is what this panel did. And many panels since then have done, which is because there was error, because there was no specific waiver beforehand, it's automatically not harmless. Because in Nunez, the review was of the trial record, what was presented to the jury. In a plea situation, there's not going to be a record before the jury because the defendant has agreed to waive his right to have any of that evidence presented to the jury. That's why the state believes that in looking at the harmless error analysis, if we get to error at all, looking at the harmless error analysis, you have to focus on the more focused Bentley test. And that Bentley test is whether there is some reasonable possibility that the failure to inform the defendant of his right to a jury trial led to his decision to admit rather than contest his age. And the state would submit that in this case, there is overwhelming and uncontested evidence that the defendant would not have not contested his age. I said that very poorly, but would have gone ahead with the plea agreement. This defendant was originally charged with 3 off-grid felonies. He, as part of the plea agreement, went to the grid. He admitted in the acknowledgement of rights that he was 36 years old. He specifically knew that he was facing lifetime post-release supervision to a crime that he was pleading guilty to. The plea agreement specifically said that he acknowledged he was 18 years of age or older at the time of the crime. Again, at the plea hearing, he told the court that he was 36 years of age. So there is no question that he would have insisted, if specifically told, you have a right to a jury to determine if you are 18 years of age, that he would have said, I want to go to trial.
Sorry, I didn't mean to interrupt your argument. just let me back up a little bit, because your argument, even, if your interpretation of Nunez is correct, and that we don't need a specific, a fact-specific waiver, so to speak, of the jury trial right, we still need a valid waiver of a jury trial right.
Yes.
Correct?
Yes.
And I'm just curious, it's a little interesting, like going through our cases, what are the central components that, or advisements that are necessary to ensure that there is a knowing waiver of a jury trial right? And did that happen in this case? I know that may not be before us precisely, but I think your argument is dependent on it. How do we know the waiver here is valid?
You know the waiver is valid based on the acknowledgement of rights forms that goes through every right that he has a jury of 12 members to decide. You have the right to be represented by counsel. You have the right to call witnesses. You get to decide whether or not to testify. The information contained in that document that the court then says, did you read, did you understand this document? Do you have any questions about this document? And then I'm going to go ahead and tell you again, you have a right to a jury of 12 members to decide whether you're guilty. You have the right to counsel to represent you. And so that's how you know that the valid waiver happened in this case.
Because looking from the record, I appreciate that additional information, and that's all tied to the record here, because it looked like at some point it was almost like boiled down to, you need just to decide whether judge versus jury. And that was sort of like, maybe it honed in on that inquiry.
That it did hone in on that inquiry towards the end of that plea hearing, because I think my understanding of the situation is the defense counsel says, we were here originally to enter a plea. My client told me right before I came in that he does not now wish to enter the plea. And so I think that there was a switch in mindset to, are you sure this is what you want to do? You've told us once that you don't want to do it. Are you sure this is really what you want to do? Here are the things that you are entitled to. Those documents, did you have any questions? The court here actually gave the defendant more time to speak with his counsel when, after explaining what his rights are and what the consequences would be, gave him more time to speak to his counsel. And the court, I read the record to say the court just wanted to make sure you're not feeling pressured. This is your decision. This is something that you want to do. Yes, but that doesn't mean that the court and the attorney did not advise him of the rights he had prior to that. If there are no other questions, the state would just ask this court to reverse the portion of the Court of Appeals panel that found that the failure to give the specific waiver in this case was error, and or reverse the decision that it was not harmless error. And specifically, if this court would set forth, if it finds that it is error, would ask this court to specifically set forth what test do we use in a plea situation. Thank you.
Any other questions? Thank you. Mr. Shire.
May it please the court, Jorge Contreras appears through counsel Casper Shire, Kansas Appellate Defender. The Court of Appeals correctly applied Nunez to a case where Jorge Contreras was not advised of his right to a jury trial on a sentence enhancing fact and did not make a knowing and intelligent waiver of that jury trial right. This court should affirm. The Apprendi error requires reversal, and the Court of Appeals got that right too. The state cannot prove beyond a reasonable doubt that the Apprendi error did not contribute to the sentence in this case. In fact, without the error, the sentence is illegal. And that's why we're asking this court to affirm the Court of Appeals, to reverse the lifetime post-release sentence, and to remand with instructions to order a 60-month term of post-release.
What would you point to in Nunez that supports your interpretation that it imposed a rule that a jury trial waiver had to be specific to age, let's say? I mean, Nunez just doesn't say that. I can't find it in Nunez.
Nunez did not deal, obviously, with a jury trial waiver because it was a case that went to trial.
Right.
But Nunez is firmly rooted in Apprendi and the line of cases that follow it.
And the only rule that I can discern, at least from Apprendi is that before a judge can rely on an admission, there must be a valid knowing jury trial waiver.
Yes.
But the body of law that defines what is a knowing involuntary jury trial waiver wasn't changed by Apprendi or by Nunez or any of those cases, right? It stays the same.
Right.
So then Nunez effectively is really not even relevant to this case, is it? Wouldn't we just look to the law of jury trial waivers and ask, was this a valid waiver or not? Because there is a waiver here, right?
There is a waiver, and I would argue that
Question is it valid?
yes, I think it is valid as to the elements he was charged with and as to the elements he pled to.
That's the question is, does it have to be that granular? In other words, why is it only valid as to some elements and not others, or some things and not other things?
I think the simplest answer, Your Honor, is because you can only be sentenced for what you plead to. As an example, if I plead guilty to battery, after having a prelim on, more serious charges, and I go into sentencing and the district court says, I recognize your plea to battery, but I heard the prelim evidence and this was great bodily harm. I'm going to sentence you to a
pled in the plea. His age was listed.
His age was listed.
And he admitted his age in the plea.
He acknowledged his age,
okay,
but there was never a connection made, and the Court of Appeals recognized this. There was never a connection made between his acknowledging his age and the sentence enhancement that would be a result
Sure,
of
but
that.
there also was not, his waiver also did not recite the specific individual elements of the crime either.
No, but
why would it be valid for the crime but not for the age?
Because he was pleading to the amended information, and the amended information had the elements of solicitation in it. It did not have his age in it. And I would point this court to the way that we do Jessica's law prosecutions in this state. If somebody is going to be charged with the Jessica's law offense, age is an element of that crime, and it's put into the charging document.
But would it have to be, let's take that hypothetical. If that was in the charging document and then at the jury trial waiver, the defendant just enters a general jury trial waiver, is that sufficient even if the court does not say, oh, also you have a right to have a jury determine your age? If it's in the information.
If it's in the information, typically that information will state what that it's an off-grid offense and that it's a life sentence. I think under those facts, yes, we've got a knowing involuntary waiver to.
Even that is not what the Court of Appeals said below. As I read the opinion in this case, the Court of Appeals said the court must specifically say you have a right to a jury determination of your age. Am I misreading the?
No, I don't think you're misreading it.
Do you see the difference between that and what we just discussed about the information? I'm just trying to decide what do district courts actually have to do to get a valid jury trial waiver?
Sure. I guess my first response, Your Honor, would be that I'm not sure the answer to that question matters in terms of resolving this case because we don't have either one here. My second answer would be, I think certainly it's best practice to go ahead and advise somebody that they're going to be subject to lifetime post-release if they admit to their age. I think that would be something that, regardless of whether it's required, should be strongly encouraged.
Well, this rule may have impact far beyond these Apprendi issues. For example, to get a valid jury trial waiver, does a district court judge have to inform a defendant, you have a right to have a jury determination of venue? you have a right to, I mean, do you have to tick through every single element? That's the question, which I admittedly may not impact your client, but it's a rule that comes out of this opinion. It seems to me the Court of Appeals opinion would require that.
Well, and if the Court of Appeals is painting with maybe too broad a brush, that might be dicta, because I think as applied to this case, he was not charged with an element that ended up enhancing his sentence. And the jury trial waiver is valid. We don't have a problem with that. We are not attacking the conviction. The problem is a sentencing error. He got sentenced to something beyond what he pled to allows. I would like to make a comment about the Bentley test. We don't believe the Bentley test is the right test to apply to a sentencing error like this one. Bentley involved a jury trial. It involved an inadequate waiver. We do not have a problem with the waiver here. This is not a waiver problem that we're trying to fix. We have a perfectly fine waiver as to a lesser offense that does not carry lifetime post-release. We are asking this court to reverse the sentence that was imposed based on judicial fact-finding.
Any other questions, colleague?
I have a quick follow-up. And it's always hard to do this on the fly at oral argument when I'm looking at the record and so on. So forgive me if I get this wrong. But it looks to me like the age of your client was in the information. His birth year was listed as 1987.
It may have been in the original information. I believe there was an amended. And if I'm wrong about that, then I'm wrong about that.
Well, doesn't that, even if it's in the original, doesn't that undercut what you were arguing a moment ago?
No, I think it strengthens it, Your Honor, because again, this is what we do all the time in the context of Jessica's law cases. They're charged as off-grid offenses. There's only one place to go if we're going to do a plea agreement in the Jessica's law context, and that's back to the grid. And how do we do that? We remove age from the charge, which is, I'll admit, a legal fiction.
So you're saying if the record supports the idea that an amended information took age out, that would
Yes.
actually bolster your argument?
Yes,
Okay.
yes, because that shows that he's pleading to something lesser, and that is exactly what we do in.
And I don't know, as I sit here, I'm not certain exactly.
Well, and
Back to
the record
I can
will,
look.
yeah, the record will be what the record will be. So
Thank you.
Any other questions? Thank you, Mr. Shire.
thank you, Your Honor.
Ms. Allen, you reserve 2 minutes.
Thank you. Just briefly, in this situation, this defendant was specifically told there will be lifetime post-release supervision if you plead to these charges. There was also provided information that you acknowledge you are 18 years of age or older. There is nothing to suggest in any way that if he had been told you can have a jury trial to determine your age, that he would have chosen to go to trial on 3 off-grid counts. The jury trial waiver in this case covered the elements. It was a valid jury trial waiver. So the state would ask this court to find that the Court of Appeals panel erred and reverse the Court of Appeals panel decision. Thank you.
Wait, any other questions? Okay, thank you, Ms. Allen. That will conclude this morning's docket. Court will be in recess until 9 a.m. tomorrow morning.